It was shocking as it appeared unreal. It was devastating given the fact of several unfinished assignments, future hopes and plans for the family, the judiciary, the church, and his hometown. All that are gone with the winds. His Lordship was during his lifetime a legal icon. He had a sure foundation which yielded his good grip of the law. He was a man of great learning and integrity. He was meticulously courageous, not minding his quiet disposition. He had a humble beginning in life, which he continued to exhibit in his humble approach to life and pleasant interactions. Without prejudice to his office as a judicial officer, he was indeed a man of the people. His judgments adorned the legal reports. His legal reasoning and approach were adorable, and many of his judgments were upheld on appeal. For me personally, I admired his grammatic construction and polite courage displayed in his writings. A quick review of a few will bring to the fore the enviable qualities of this great jurist that lies still before us. Writing on abuse of office, respect for rule of law, and court, and committal for contempt. His Lordship stated and adopted thus, in the case of Omar Khalif against the Honorable Minister, Federal Capital Territory, he stated, that was on 9th January 2020, the party cited conducts in this manner. The party cited conducts in this matter are not only invidious, but are aimed at denigrating this court and smirking its nobility, majesty, aura, and responsibility. The smirk of abuse of office, unbridled arrogance, and utter disrespect of the law and institution of the court. Stern measures are provided by the law, ought to be taken against persons with this kind of disposition, to serve as a deterrent to future occurrence or perpetration, not only by him, but also like-minded deviants. The party cited had ample opportunity to retrace his steps and abide by the law, but he chose otherwise. The dignity and honor of the court cannot be maintained if his orders are treated disdainfully and scornfully, without due respect, as has been seen in this case. I find the party cited guilty of contemptuous disobedience of the order of court as handed down by His Lordship A.S. Omar, as he then was. The right and power of court to punish or pronounce sanction on whoever disobeys this order is inherent and legitimate right of every court. Disobedience of a court's order is a serious contempt, and courts of law must protect themselves from being maligned and ridiculed. End of quote. Further on the need for our security, law enforcement, and prosecution agencies to patiently conduct proper, watertight, and unassailable investigations before suspects are arraigned in court, especially in the fight against corruption. His Lordship wrote, that was in the case already mentioned, Federal Republic of Nigeria against Adeni Francis Adetokunbo Ademola. He stated, before my ink dries, let me quickly mention that this court did give very serious thoughts to the circumstances of this case. There is no gainsaying that the case is built on high-level suspicion and speculation, fueled by the enthusiasm of the very important Nigerians' current fight against corruption. While such level of suspicion and speculation can, in the eyes of the pedestrians and uninformed ordinary citizens in marketplaces, suffice for the defendants to be condemned so as to give fillip to the fight against corruption. In the eyes of the law, however, the suspicions do not measure up to the standard required for the defendants to be condemned to further trial. End of quote. Also, in the case of Unique Future Leaders International Limited against Federal Capital Territory, His Lordship said, Against the background of the foregoing, I come to the view that a business name does not possess the legal capacity to hold or acquire land. This implies it does not have the legal capacity or standing to have title in land vested in it. The learned third defendants' counsel's submission that business name is a juristic person which can sue or be sued in nomine, following the provisions of the rule of court made pursuant to an enactment, is misconceived. The misconception is that a capacity to sue or be sued provided for under an enactment is not same as capacity to acquire or hold land. I must emphasize that his courage was quite admirable. He handled assignments given to him with precision. His profile really speaks volumes. No wonder he received so many commendations from the almighty Nigerian Judicial Council. As judicial officers readily confirm, the fear of Nigerian Judicial Council is the beginning